Welcome to this CIArb panel webinar discussion, 25 years since the Housing Grants, Construction and Regeneration Act. I'm delighted to be joined here today by such a well-spread audience and also such an eminent panel of experts to really discuss how adjudication has evolved since its introduction in the UK in 1996, 25 years ago. My name is Lewis Johnston. As I said, I'm Assistant Director at the Chartered Institute of Arbitrators. And my role really includes our policy and external affairs remit, so influencing governments both in the UK and around the world to promote the use and propagation of all forms of non-court dispute resolution. And also the CIArb Dispute Appointment Service, within which our adjudication panel and offering is a key pillar of our mission to promote the use of dispute resolution, particularly in construction. So, as I said, the theme of today's webinar is 25 years on since the introduction of adjudication. We will be exploring with our panelists the context to the introduction of adjudication back in 1996, what it was intended to achieve, how it was designed, and also how it was received within the marketplace. And I know that many of our panelists at the time had quite strong views on what that would entail and what it meant. Then we will look at how it has evolved in the 25 years that have passed since. Some of the reforms that have come in to play, how some of the issues that may have been identified in those early years were dealt with. And then we will look to the future, particularly at how adjudication is evolving now, what some of the issues are, particularly perhaps around low value adjudication and the CIC low value model adjudication procedure, and really examine, as we look to the future, how can adjudication remain relevant and how can it continue to achieve what it set out to achieve all those years ago. As I say, I'm very lucky today to be joined by such an eminent panel of speakers. We're joined by Matthew Drake. Matt is Managing Director of Drake Quantity Surveyors Limited. He lectures at the University of Salford on the Quantity Surveying course, acts as an adjudicator and also as a party representative in adjudication proceedings. He's the chair of the CIArb Northwest branch and a member of the CIArb Board of Management. We're also joined by Kim Franklin QC, a recognised specialist UK construction adjudicator and international arbitrator in the engineering infrastructure sectors, focusing on major projects and the resolution of high value, technically complex disputes involving project delay, PFI and FIDIC contracts. An accredited adjudicator with CIArb, TEXA, TechBar, REBA and IChemE, Kim has a reputation for clarity, strong case management and sound strategic judgment. Nicholas Gould is an arbitrator, adjudicator and mediator and a partner in the specialist construction engineering and energy lawyers Fenwick Elliott, where he conducts a mix of international dispute resolution and non-contentious work. He acts for contractors, employers and government in the building, construction, engineering, infrastructure, transport, energy, oil and gas and process engineering sectors. So it's obviously quite a remit. He's president of the Dispute Resolution Board Foundation and past chairman of the Society of Construction Law. Tom Hawkins is an associate quantity surveyor in the Arcadis Quantity Solutions team with over 12 years experience in the construction and engineering industry, working for both contractors and consultancy. He has experience of multiple adjudication proceedings as a party appointed quantum assistant and is working towards becoming an adjudicator. And finally, Matt Malloy is an experienced dispute resolver and has been appointed in over 800 construction and engineering disputes as either adjudicator, arbitrator, mediator, expert determiner, conflict or dispute avoidance panel board member. He is on the RICS, TEXA, CIArb, CEDA, CIC, CIOB and REBA panel of adjudicators, as well as the Irish Government panel of construction adjudicators. So welcome to all of our panelists, and I'm very glad that you're able to join us here today. Just a bit of housekeeping before we start. This is a panel discussion, but we do hope that it's interactive. We really want to hear questions from you as an audience. You will see on your Zoom page, hopefully you've got a chat function. You can use that for general discussion. I see many of you are already introducing yourselves and where you're from, and that's great. And if you have any technical problems, you can raise it there as well. There's also a Q&A icon. This is if you have any questions for the panel. Now, the way that we're going to order things today, firstly, we'll hear from our panelists and hopefully get quite a lively discussion going. We've dedicated 20 minutes towards the end of this session, so around 10:30, 20 to 11, specifically to address audience questions. However, if you've got a question during the discussion, please do share it, because if it's relevant enough, then our panelists will want to hear it and we may be able to address it straight away. And if not, we will hopefully be able to get to it later on in the session. We're also going to take a poll in just a second. So when the poll is live, you'll see it on the screen. We're going to do that at the beginning of today's session and then towards the end. And then also, please do share your experiences and your participation in today's event on Twitter. You can use the hashtag CIArb, and it'd be great to share your thoughts on what we discussed today. So, first of all, I'm going to just bring up the poll to just gauge where the audience is with regards to how adjudication has fared since it was introduced. So this first question should be on your screen now, and people are answering. Do you think adjudication has achieved what it was intended to deliver when it was introduced? Now, we started out with 100% saying yes. I see very rapidly everyone is answering this question. Be interesting to see how this compares towards the end of the session as well. I think yes still certainly has the edge here, although the percentage is coming down as more and more of you vote. I'll just give it a few more seconds for anyone else who wants to participate. Okay, so most of you have now cast your vote. It's a clear win for yes, but some significant numbers for no and don't know. So 77% of you believe that adjudication has delivered what it was intended to. 17% of you, that's 25 of those who are present, say no. And 7% don't know. So it'd be interesting to see how that develops over the course of the discussion. So in order to set a bit of context for our panel discussion, I wanted to open with a discussion of what led to the 1996 Act and exactly what issues it was intended to address, and how it was meant to make dispute resolution in construction more effective. Now, Kim, I know that you had some very strong views at the time, and I trust also have some very strong views on adjudication now. So I wondered if you could start just by setting the scene a little bit about what led to the 1996 Act, and then what the initial reaction was from the market, but also from yourself at the time.
Lewis, thank you very much for that introduction and for that question, which is based on the premise that I was around in 1996, which is a year that was made famous by Prince Andrew's divorce, Dolly the sheep, and as we all know now, by Gareth Southgate's penalty. So I don't know what's more alarming, the fact that I've been asked this question, or the fact that the answer was yes, indeed, I was around. And So I can tell you a bit about what life was like before adjudication. So back then, construction disputes were long, multi-party, expensive affairs. If you had a damages claim, the chances were there were about 8 or 10 or 12, 15 defendants to your claim, and that claim would be heard in what was then the official referees courts, now the TCC. And one of my first briefs was a noting brief for a 12-week trial, and that was quite typical of what was going on then. If your claim involved opening up, reviewing and revising a certificate issued under one of the standard forms of contract, after a landmark decision in Gilbert Ash Engineering, all those claims had to go to construction arbitration, where in the main, the arbitrators were specialist construction professionals and not lawyers. So they were very familiar with the subject matter, but less familiar with the procedures for resolving disputes. And if you had a smaller claim, then you were seriously unlucky, because you would end up in the county court where your dispute would be tried by a generalist judge, and some of whom, the minority, but some of whom may have actually heard of a JCT contract. So the deterrents against disputes, time, cost and delay, they were exploited regularly by cash-rich contractors and employers against cash-strapped subcontractors and smaller contractors. So Sir Michael Latham was asked to review procurement practices in the industry back in 1994. He reported, and it's an extensive report, and it's mostly about payment and other procurement issues. And he put in his report a 1-paragraph recommendation introducing adjudication as an on-site dispute resolution procedure up to practical completion. 1994. 96, the Act was passed, and that's 2 years later, and it contained a number of provisions which went way and beyond those that were envisaged by Sir Michael. Most memorably, the ability to refer a dispute at any time, which meant long after completion. It also included construction professional negligence claims, which was way beyond the scope of what Sir Michael had recommended. And it excluded a whole raft of heavy-duty process engineering disputes in response to a very powerful industry lobby. Now, Sir Michael said at the time that the Act, as it was formulated, was not what he wanted. He said nobody had asked him, and there was a rumor going around at the time that the legislation had in fact been drafted by a biologist, which seemed to us to explain a great deal. It then took another 2 years to sort out the scheme for construction acts, which we know 1998. So that was 2 years for the industry to think about adjudication and talk about it before it actually happened. And then it was another 2 years, because we're all rather conservative, lawyers and construction industry, another 2 years for it really to begin to be used. And the first adjudication enforcement case, McCobb and Morrison, was decided in 1999. And I think our fellow panelist, Nick Gould, actually commentated on that at the time. So it wasn't really until the dawn of the new century that adjudication started to take off. How was it received at the time? Well, it had a very mixed reception. The industry was fully in favor of it. They saw it as quick, cheap and dirty dispute resolution. It's exactly, they said what they wanted. The lawyers were dead against it. Really, because this brand new process that had been forced upon anyone who'd had the temerity to enter into a construction contract had a whole list of known unknowns. And particularly, what the process was all about and how it would work in practice. As lawyers, we were going to have to advise people about it, and we simply didn't know the answers to the questions that they were going to ask. And a view, certainly my view, but it was also a view that was prevalent at the time, was that this may be quick, but it was going to be expensive and probably wrong, and of course only temporary compared with arbitration, which gives you final resolution. And some of our listeners today may remember I did a science fiction based presentation on this topic, comparing Star Trek's Captain Kirk for representing arbitration and Doctor Who's Dalek representing adjudication. And my views were well known to anyone who was reading the industry column that I was writing at the time. And just to conclude on a little anecdote to illustrate the point, I went along to a training day which was run by a brand new adjudicating nominating body called TEXAR. And I sat next to a quantity surveyor, and he wanted to know what on earth I was doing there. He was absolutely horrified of the idea that an adjudication might be decided by a lawyer. He said it couldn't possibly be what Sir Michael had intended. But of course, if you look at his report, you look at the legislation, you look at the scheme, it says nothing about the profile of an adjudicator. And now more adjudications are decided by lawyers than any other discipline. So a question for the panel and the audience is, would poor Sir Michael turn in his grave if he now knew that?
Thank you very much, Kim, and I think that's certainly something that we can chew over, hopefully, during the course of the discussion. You mentioned there about the distinction as well between how the Act was received by lawyers and then perhaps by others within the construction industry. And I wanted to bring in Matt Malloy at this point, just to see, again, I know that we'd previously discussed, Matt, about your own reaction at the time and how this was, what the industry perspective was on the Act. Can you follow on from what Kim was discussing there?
Yeah, I mean I was around in 1996, but not really dispute resolving. But I had my first foray into it. So I'll probably go back a little bit to when I came into the industry and my perception of the disputes. And so I came in sort of late 87, and fresh out of college, we were told about this boom bust cycle that happened in the industry. And I suppose my introduction to the industry was a sort of coming up to the sort of the early 90s boom, so late 80s, sort of 90s boom. So as long as you could drive and use a calculator, you could get a job as a QS generally, and that was what I ended up doing. And then the 90s hit, and so that was my first experience of the bust. And what I came to learn quite quickly was that there was these weird bearded people who used to spend years in the room at the bottom of the corridor, never actually going out on site, but they were picking the bones off these jobs that had finished 3 or 4 years ago, trying to manufacture is probably too strong a word, but evidence perhaps their employers or whoever had instructed them's case to try and put together a claim that they would then prosecute or defend in one of the forums that Kim's spoken about. And so I learned that actually this boom bust cycle worked in opposite if you were in the disputes business. So generally, while we were sort of scrapping around and saying goodbye to colleagues who were being made redundant at the end of each month, the disputes team seemed to be doing very well out of this and spending an inordinate amount of time involved with these claims. So I wasn't really aware of what or how these things were prosecuted, other than sort of seeing that we seem to be spending a lot of money on people looking at old jobs. And so when I then sort of came to be involved with disputes, which was about 96, and I heard about these plea for sanity collection of papers and all the rest of it. I didn't really take much interest because I was just sort of starting out, leaving my proper job to sort of go along this path. Ended up in an arbitration and I was told that the arbitrator had just died, when I was sort of quite shocked by this. And I thought, oh no, what's going to happen? Who's going to decide your case? They said, oh, don't worry. We always insure the life of the arbitrator because these things go on. This thing's been going on for 4 or 5 years. And it was about this is where were we? Yeah, 96, 97. This was a job that we finished in 1990. And it still had a couple of years to go, and we were nowhere near the hearing. And at that point, I hadn't really thought about the ills of the industry. I thought, well, this seems like a really good place to get involved with. It seems like I can maybe do some construction work when it's booming, and then when it's not so rosy, I can join these weird bearded people, spending years at a quite decent day work rate, sort of doing dispute resolution. But on a sort of more serious note, I think that what I got loud and clear was that there was dissatisfaction in the industry in terms of if you were dragged into this dance, as I refer to it, either litigation or arbitration, where you're effectively dancing with the gorilla. You stop when the gorilla stops dancing, and it was I think especially if you didn't have the means to prosecute these claims, you'd effectively either go bust or walk away from it. And so you were forced into, those with the deepest pockets generally dictated the terms. And so that seemed, something that the industry said, well, we're not prepared to live with this anymore. And I think that was where, I suppose I understand retrospectively now, that's where Latham came in. And I think what I perceived at that time was that there was a tension. There was a tension between people perhaps protecting their own sort of the way things had always been. So you had maybe the legal fraternity who were sort of saying, well, we're used to these long trials and we can have our teams involved with this case for 12, 24 months. And there was a concern that might dwindle. That was my perception. But then you had the industry saying, well, this isn't fair, that I can't actually prosecute my claim till after the job's finished. In the meantime, I haven't got any money to be able to prosecute that claim. So, where do I go? And so I just think there was perhaps some competing interests there. And I don't think there's any doubt in my mind that Sir Michael's report was a result of successful lobbying and support from the construction industry, and probably in particular those who had suffered historically. And I think that, I suppose it depends where you are. It's like the bully in the playground, isn't it? The contractor might be bullied by maybe the public sector client whose money's not necessarily a thing, or it may be the subcontractor further down the supply chain who's suffering from the larger, what we would call now a tier 1 contractor. So I think that was really where the report was coming from. And I suppose you need to think as well, at that time, mediation hadn't reared its head. So really there was little option. You either put up, shut up, or found the money to prosecute. And I think that's really where the industry were coming at it. And so, I mean, I was quite, going into the world of dispute resolution, I was quite keen, because I thought, well, I thought this is an area, where potentially, if I want to be involved with dispute resolution, there'll be more of it, because you are lowering the entry level to dispute resolution. Now, whether that's a good or bad thing, I don't know. I suppose it depends where you're coming from. If you're a dispute resolver, that's great. If you're the one who's writing the checks, maybe not. I don't know.
Thanks, Matt. I think it's hearing from both you and Kim, I think we've got a good sense of where the fault lines were in 1996, and I think that's quite important then for understanding how adjudication has evolved since. I'm conscious that we've got 3 other eminent panelists with us today. Please do feel free, Nicholas, Matt, and Tom, to switch on your cameras. And if there's anything that you wanted to, I wonder if there's anything that you wanted to add or address in what Kim and Matt have just said there. Nicholas, I think you've got something you wanted to say.
Well, yeah. No, it's really great to be reminded about how we've got here on this journey. It only feels like yesterday that it all suddenly came into being. And I must say, I really now associate with the state of trying to resolve disputes that Kim was talking about, how long it takes. And also, I mean, before, I mean, I started out life very much like Matt. I went on the building sites as a QS in the 80s and found the same sort of pathway. You know, you finish a job and you think, this is great, I'm off to the next job. And you did this for a few years, and then suddenly a job got these claims and these problems, and it took longer to fix than the whole thing took to build. And you know, there are plenty of people that think that's a bad way to do things. We just focus on the new project, and lots of the people go to the new project and hope that the old dispute just goes away. But there's a real utility in all those people that actually, you know, try to work out the account, the dispute, the problems, whether it's adjudication, mediation, whatever it is, because you have to do it. And I must say, when I first got involved in the sort of mid to early 90s, and all these processes were coming along, adjudication and ADR, I thought, well, gosh, I'm not going to have a full kind of career with this. I'll have to go back to building stuff again, because it all makes so much sense to crack these things quickly. But we still today have the same disputes we had then. And as Matt and everybody else knows, you know, we still repeat on projects the same problems about value and delay and unreasonableness that people have. So,
Thanks, Nicholas. Tom or Matthew, is there anything that you wanted to come in on there?
Yeah, excuse me. Thanks, Lewis. I think it's really interesting hearing from people with probably more experience than myself, certainly that were around at the time. You know, the Adjudication Act was brought in and sort of dealing with it in its infancy. Because when I first started in the industry, adjudication was already a big thing. It was just there. You know, it was part of the contracts. The scheme was already there. I think the case law was sort of well developed when I started, and I find it really interesting to hear from people how it was before that and to what it is now, and some of the queries and the questions and the problems that seem to get raised. And as Nicholas was just saying there, you know, we're still seeing some of the same things coming through, the same disputes being brought to adjudication. And it's interesting to see how adjudication might have actually, you know, has it actually helped the process, or has it hindered it, or, you know, has it been a good thing in that approach? So it's really interesting to hear from you know, sort of both sides, I guess, of that coin in terms of when the Act was introduced.
Yeah, absolutely. Thanks, Tom. And I think it's interesting that the initial poll that we took clearly showed a large majority of our audience here today feels that adjudication has been a success in terms of delivering on those intentions. Although it was a large majority, but by no means completely overwhelming. There were different views as well, so it'd be interesting to see how that changes over the course of the discussion, if at all. Matthew, I'm just conscious before we move on to a discussion of what's changed in the last 25 years. Was there anything that you wanted to add?
I'm going to say no, Lewis. I think what Tom has mentioned and what Matt, Kim, and Nicholas have mentioned is, you know, there's nothing more for me to add to that, really.
Sure. No. Thanks, Matt. I think we've established a good basis there anyway to look at what's happened since then. And I wanted to bring in Nicholas at this point. Just to run through what you see, and I appreciate even if we dedicated the entire hour and a half to you here, Nicholas, it wouldn't be sufficient to run through everything that's changed in the last 25 years. But I suppose we're testing your ability to summarise here. But if you could just run through what you see as being the main milestones over the last 25 years, and what's changed.
Yes, okay. I'll try just in 5 minutes or so to skip through, you know, I suppose things that stick in my mind, because of course when we first started with this, no one was quite sure it was going to work, and I remember the Act came in '98, and I was working with Masons at the time, and we were all waiting to see which client went first with this, and no one seemed to want to. You know, you're kind of waiting for someone to go first, and then there was an enforcement in '99, this case of McCobb. and that opened the doors really. The judge really did enforce it, and everybody thought, gosh, this actually really works. It's not just words on a piece of legislation. And so you saw a real build up after that. We had the first Court of Appeal case, which is Boygendal Jensen, confirming that the adjudicator can get the law and the facts wrong, and it will still be binding, subject to very minor things, that challenges to jurisdiction and so on. And I suppose that's really the game began. What is a jurisdictional challenge and what isn't? And I always think of them in two categories. There's the threshold challenge. Do you get across the threshold? Is the door open? Is the adjudicator in the room? And that's quite a difficult one, because if there isn't, if the act doesn't apply, or if the contract provides for a different A and B to make the appointment to the one that's made, you have no jurisdiction. But actually, once you get in there, if you have jurisdiction, it's quite difficult to lose it. But you can lose it by breaches of natural justice and maybe not answering all of the questions put. So that's been quite a few games with that over the years. And then aside to that, we have the question about what is a dispute, how many issues, matters can you have in a dispute? Do they all have to be linked or not? And more recently, it seems to have been decided they don't have to be linked, provided anybody's in dispute. You can cherry pick out the bits that you want for your adjudication. And when the dispute crystallizes, is the dispute already formed? Can you go off to the adjudicator, or is it too soon? And then I suppose the scope of the defences, because the notice, when you serve the notice, that sets the parameters of the dispute. But how wide can you be in terms of your defence? And that starts to bring us, I suppose, a little bit more onto the changes that suddenly occurred with LDEDCA when they amended the payment provisions, because we've kind of in the past few years got into payment disputes. In reality, they're not about payment at all. They're about, did you serve the right notice? Smash and grab is the name that's often used. So there's quite a lot of that going on. And the adjudicator there doesn't get a chance to do a true valuation. The bit they're good at, looking at the actual cost and delay and so on, it's just a case of, well, there was or wasn't a notice, there was or wasn't a default notice, maybe there's a payless notice, maybe there isn't. And that's sort of where we are, I think, with some of that, which is a bit of a shame, really. The other things that have occurred along the way was the Human Rights Act reared its head suddenly. There was this whole argument about whether it's fair. Do you get a right, a proper right to be heard properly in such a quick process? And that seemed to have been knocked on the head quite quickly with the whole idea that it's not a final determination, it's only temporary, so it doesn't apply, and that's died away. I suppose as we get more up to date, though, with the smash and grabs, we're also looking at things like insolvency, and that's the big case recently with Bresco. It seemed quite interesting, really, and that case isn't. There's more to come, really, from that, because the question there is, well, if there's an adjudication and one party is insolvent, what's the point of having an adjudication? Because you won't get the money anyway, because it will be stayed, and probably there isn't any money in the pot, because construction insolvency is traditionally, a couple of pence in the pound is what we've seen over the years. But in Bresco, they confirmed that you can still have your adjudication, even with cross claims, to liquidate the amount. And then that goes in the pot and the insolvency practitioner deals with it. But there'll still be more to come in relation to how that all plays itself out, I suspect. But that's the most recent point. I suppose then, just looking back over all of it, over 600 cases in 20 odd years, you would think all of the points have been answered, wouldn't you? But probably not. But I think a lot of the big ticket items have been answered, and we know what we're doing. Adjudicators know what they're doing. We check for jurisdiction and get on with it, really. And I think that's the message that the courts have pushed out to everybody. And I think from that perspective, it's been pretty successful, because there are basically practically no domestic arbitrations. Why do that when you can just adjudicate? And the leftover matters that go to the court get done very quickly, because rather than spending years getting to court, it's now 12 months or so in the technology court. So I think it's been pretty successful, really. And if you look back at some of these big ticket items, you can place yourself reasonably well in terms of understanding how the process works and issues and problems to look out for. And there's a bit of guidance on some of the CIArb guidance notes and on some of these points too. Anyway, that was really all I wanted to say. And if there's some questions about any of that, it would be probably more fun to debate them than for me to just talk about them.
Thanks, Nicholas. I think that was that was a masterclass in a succinct summary of of really quite a extensive 25 years of case law and developments and
I've
so on.
forgotten
So,
lots. I wish there were so many other things I wanted to say, but it's just to the point, really. Thank you.
no, I think that was really excellent. Kim, I think this would be a good, in light of what you were discussing earlier, and your initial kind of views on the introduction of adjudication. Has some of the developments that that Nicholas alluded to there, have any of those changed your view, and could you talk about how your perspective may have evolved over the years?
Absolutely. I said that the lawyers were against adjudication because there was this long list of known unknowns, not to mention the unknown unknowns, and anyone who went out to the industry to introduce this new procedure before it started and started to say that they had misgivings about it, they were pelted with rotten eggs and squashed tomatoes. But over the certainly the following decade, a lot of these unknowns were sorted out by the courts. And to begin with, it was all rather chaotic because people were coming at it from all sorts of different angles. The McCobbin-Morrison case, for example, was decided by Mr. Justice, now Lord Dyson, who, although he'd practiced as a construction silk, had spent all his judging time doing admin law. And so he came back as a judge in the TCC, and one of the first cases he had to decide was whether someone he'd never heard of, an adjudicator, had something that nobody knew about, jurisdiction, to decide a dispute that nobody understood, and whether it was whether it could be enforced as a summary judgment application. So a very interesting perspective that he brought to it, and it sort of set the scene for, well, everything's up for grabs, really, and a lot of people put that to the test over the ensuing decade. And it really took Rupert Jackson and Peter Coulson and Robert Aikenhead, if I can give them their names without their titles, because they've all moved up and on. Really, they took the whole thing by the scruff of the neck and started to sort it out. And once we had good accessible decisions as to what a dispute was and what a breach of natural justice was, and no, I'm not going to avoid enforcing this decision because it was written on the wrong color paper, then the industry sort of settled down and got on with it. And also the fact that it stopped being used for professional negligence claims, for example. I mean, I was as practice as a barrister doing a lot of work for insurers who were absolutely horrified by the adjudication process. Something that happened in 28 days. Can you imagine an insurance company? I mean, you know, they'd hardly read the letter by the time the decision was issued, and then they were supposed to stump up sometimes hundreds of thousands of pounds on the strength of something they really hadn't had time to take part in. So once the professional negligence claims settled down, but also the industry realized that if you wanted a quick, short answer on a difficult legal issue, well, blow me down, you could go to a lawyer adjudicator and get an answer which might actually be sufficient to crack the dispute, or at least move it forward for present purposes. So I think things settled down enormously. There was also a raft of A and Bs. I don't know whether you remember, you know, everyone was setting up on a street corner in a little stall with adjudicator nominating body and saying, you can only join my club if you've got these particular criteria. And the A and Bs kind of settled down into, I mean, the Chartered Institute is, of course, a marvelous paragon example of how a good A and B can operate, with a cross-discipline panel of adjudicators, and everything has now got to be rather good. But it did take a while, and for those of us who were involved in the white knuckle stages of adjudication, and it's worth remembering it didn't come fully formed off the press, as it were.
Thanks, Kim. I think that's a very good point as well about the need to have multidisciplinary panels drawing on a wide range of skill sets. And it's interesting, one of our audience members has made exactly that comment. It's helpful that panels contain members of different professions. None has a monopoly on ability, and I think that's interesting, particularly in light of what you said earlier about the fact that the Latham report didn't specify exactly what the profile of an adjudicator would be, and therefore the need to make sure that that they're suited to the dispute in question. I wonder if our other panelists had anything that they wanted to add to anything that's just been said. And I saw, Matt, you put your hand up straight away.
Yeah.
So
yeah, no, I think I echo a lot of what Kim says, and I think what I saw quite early on was that the lawyers and the legal teams embraced adjudication, and I think combined with the support from there was a transformation from there was a change from the official referees in terms of the status moving to TCC, and I think combined with the lawyers and the TCC, I think they effectively shaped adjudication and how it's become what it has become. And it's interesting now when we're sort of looking in particular at the internationalization of adjudication. They're very much looking at the UK and what happened there, and I suppose it's brought to my mind the thoughts. Well, perhaps what happened here isn't necessarily appropriate in different jurisdictions, because it's very complex in terms of the different sort of influences at play. I think you've got some influences in terms of the privatization of dispute resolution, and what I mean by that is that the public purse, is it best spent on clogging up court time with private corporate organizations, or is it better placed to spend money on locking up bad people and prosecuting criminals, and the industry can sort itself out, but we'll police you and make sure you're doing a good job and not guarding against perhaps you falling into the criminal fraternity by taking bungs. And I guess the civil version of that is the bias issues, and I think we've seen some of that in over the years come to the fore. And I don't mean fraud in the real sense of it, but I'm thinking that the ability of parties to perhaps manipulate the selection process or to get their pet adjudicator, that's obviously something that needs to be guarded against. And I think the courts have done quite a good job in terms of getting that particular getting the house in order there. So I think there are a number of reasons why adjudication has perhaps turned into fast track arbitration. Well, but that's what we know, or what we knew. And in fact, a lot of the case management techniques that the official referees were putting in place were way ahead of their time in terms of litigation. And it was, okay, how can we do this more efficiently? And the need was this, the fact that these disputes were taking so long. And I think that perhaps on roller skates is where the adjudicators have had to sort of operate in terms of that environment. It was just interesting how it's evolved, but I suppose I think that the process is akin to fast track arbitration, and it's a very complex process, and I'll leave it to others to say whether that's a good or bad thing. But I think that is it the fix for everything? Potentially it could be, but is it a case that certain claims can't be prosecuted because even this fast track process is expensive? And so maybe there's still a certain category of claim or dispute that this process isn't suited to.
Excellent. Thanks, Matt. I think just at this point, I just wanted to address the fact that we are getting several questions through in the Q&A function. So thank you to everyone for that. Please do keep them coming. I think we're going to move on in a moment, I think, to how adjudication should continue to evolve and change, and whether it can maintain its popularity. But it has been pointed out to me that there is an assumption in the title of this this webinar. We've said, how can adjudication continue to meet the needs of the construction industry? Well, implicit in that is the sense that adjudication does meet the needs of the construction industry. And I wanted to, we've asked a variation of this question, but I think it's subtly different. And I'm going to bring up poll question number 3, just briefly. Do you think adjudication does meet the needs of the construction industry? And straight off, I think we've got yes in the lead. I'm just going to allow some more time for these to feed through. But again, it is quite striking that we've got it's a similar percentage. I suppose that might be to be expected to the answer to the first question on whether adjudication set out what it was designed to achieve in 1996. That's very interesting. I think in the light of that, it would perhaps suggest that what is needed, and there have been some questions here about some of the issues that have emerged around adjudication, particularly perhaps prohibitive costs and so on. And how they may be addressed, and we'll come to some of those questions in a moment. But I'm just interested to see where the audience is with regards to that. Before we move on, and I'm going to bring Matthew and Tom into the discussion in a moment to talk about how they think adjudication may need to evolve or be iteratively kind of changed going forward. But one of the questions that has come through here is that adjudication is becoming more complex and expensive than it was originally. Perhaps in light of the 600 decisions that Nicholas alluded to as well. Obviously, things become layered over the years, and some have suggested that we may need to get back to basics, as it were. Do the panelists have any particular views on what can be done to simplify things and perhaps get back to the less complex and perhaps less expensive approach that was in place before? Are there any particular views there?
Go on.
Matthew, I think you're just on mute. There we go.
I do, Lewis. Sorry to cut over you there, Nicholas. I think, and I don't want to take too much away from what we're going to talk about in a few moments, but there is a procedure in place for a less complex process. And also, I think if it's less complex, then there is not necessarily a requirement to have, and I don't want the lawyers to be shouting me down, but to be represented by law firms. I think that we could get to a point where quantity surveyors, project managers who are skilled could actually represent themselves, but possibly in a different procedure to what we have at the moment.
Thanks, Matthew. I think that's really interesting, and I think particularly with the obviously last year we saw the launch of the CIC low value model adjudication procedure, and as well we will be discussing that, as I'll explain towards the end, at a further event as well. Nicholas, was there anything that you wanted to add there as well?
Yeah, I think this point does come up often, and I think it's just interesting just to stand back and try to objectively look at it. If it is a small dispute, then yeah, these fast track processes are exactly what we should be doing. But if it's more, if it's a fairish value, are people saying we shouldn't really worry about what the contract says, we should let the adjudicator pretend they're a valuer again? Or are we saying, actually, we do need to decide in accordance with the contract and the facts? And it's all a bit too complicated because someone makes a contractual argument or two along the way. And imagine if you're the paying party and the claim is many millions, you don't really want to let your neutral person decide it without making some representations. And if you think there's no liability under the contract for various reasons, these things need to be put forward, surely, because the adjudicator has to decide that, the facts, the contract, the law. And then, sometimes people say it's all getting a bit complicated because they just want the adjudicator to step in and do a quick valuation. But we do have to remember, I think, that it's has to be a fast but fair process based on the legal relationship and the actual facts. And sometimes this means, unfortunately, digging around a lot. But it's much better, I think, doing it in 28 days or maybe a bit longer if it's a higher value dispute than spending all those years in arbitration.
That's an interesting point, Nicholas, about the balance between efficiency and the integrity of the process. Matt, did you want to come in there? I saw your hand was up.
Yeah, I think one of the things for me is that it's all about horses for courses and the flexibility that the process can vary. And I just recently had to deal with a timetabling wrangle on there was a big number and complex, potentially complex, because I haven't seen the defence yet, but I'd imagine it's going to be complex. But I had to effectively give my view on what was an appropriate timetable, and I sort of then made me think, and I thought, well, actually, yeah, you get a sense that there are certain disputes that can be resolved in 28 days and shorter, and the payment technical notice issues can well be done, in that period, and other issues. But there are others that seem to fall in that 100-day category, and which is 3 months, and they are expensive. The sums in dispute are significant typically, and either public authorities or companies who've got duties to their shareholders need to make sure they do the best thing, because they'll be delegating their responsibilities if they didn't fight these things, or in the way that they do. But I think the question then comes, well, why would they spend potentially six-figure sums on prosecuting a claim that they can't recover that sum of money? Well, it's because the alternative is more expensive and goes on for longer. And so if you put in and I often see it in mediation discussions about the non-recoverables of those other processes, I think that actually, it perhaps does still meet the need of giving the industry what they wanted, a faster result. And actually, if you get the right person for the job, somebody or a decision that the parties will respect, or at least then perhaps move on to discuss things. So I think it's a case of just making sure that the procedure is appropriate for the dispute and the degree of importance that the parties attached to that dispute. And I'm not belittling the small sums, because I think what we would perhaps consider to be a small sum for somebody that is their livelihood and they're living hand to mouth, what we consider to be relatively modest sums are quite, could be life-changing for others. So I think it's a case of just allowing all types of disputes to be resolved in an appropriate manner, or maybe it's the mallet that affect, the threat of dragging somebody in, and the insolvency point, I think, is a good example of this, is that the companies that perhaps purchase, for want of a better word, the debts, they're just looking to collect as much money they can for the liquidator, and it may be just pulling the trigger the nuisance value gets them some money in the pot. And I think, it's not, you don't actually need to get a decision. It may be that the notice of adjudication does the job.
Thanks, Matt. Tom, did you want to come in, and then I'll move on to looking towards the future.
Yeah, thanks. Excuse me, thanks, Liz. I was going to bring this up later, but I think it's probably pertinent to bring it up now. Just picking up on the points that have been made around the adjudication process being like a mini arbitration trial, and the cost and the speed that maybe is involved in it. And forgive me if you may, one of the things we do at our case is to release a disputes report every year. And that disputes report looks at values of disputes, time taken to resolve disputes, the method of resolving dispute, and the causes. And I just thought from this year's report that was sort of released back in June, two things sort of really stand out for me on that. And number one is that in the UK, our report shows that adjudication is still the number one dispute resolving method in the UK. And when you look at globally, it doesn't really appear at all. So I think that is probably mainly due to the Housing Grants Act being introduced. But obviously it probably shows the popularity of it as well, and the fact that it potentially is working. And going back to the question you were asking the audience earlier, about, does it meet the needs of the industry? Is it actually working for the parties? Clearly, it must be doing something, because it is so popular and it's still being used. I know that's probably a simple, indicative, holistic level to look at it, but it wouldn't necessarily appear so highly if it wasn't. I mean, when we looked at other regions and jurisdictions, adjudication only really appeared in continental Europe, and it was quite a way down the list. And I'm sure it does appear in Asia as well, but it's not very highly used worldwide. So it's great to see that it's used in the UK. And then one of the other things I thought worth just bringing up is the average length that it takes to resolve a dispute. Now, the average length that we look at, it captures quite a lot of data. But in the UK, we are seen as the jurisdiction with the shortest time to resolve a dispute. So again, I imagine a lot of that is driven by this adjudication process. And when you bring in sort of what Matt, Kim, and Nicholas were saying earlier, about the fact that arbitrations and court cases were taking numbers of years to actually resolve, the fact you can get a process that does it in 28 days, it does appear to give you, that temporary binding decision, and it does give, as long as you get a quality decision. Actually, I think the parties do respect that, and they do see adjudication as a real benefit. And I wonder if that, bringing that into that little bit of context, perhaps influences some of the answers we may get at the end of this talk, when you think about, has adjudication actually been effective?
Yeah, thanks, Tom. I think it is an interesting point that people, ultimately vote with their feet, and that does indicate something. I think with the point about, obviously the topic of discussion here is the UK, in the introduction of statutory adjudication in the UK. It is interesting that we are joined by quite a global audience, judging from what's in the chat here, and so it'd be interesting perhaps a little later on to hear from the panelists about how adjudication has been taken up in other jurisdictions as well, outside of the UK. But before we come to that, I wanted to bring in Matthew to just to talk about where we are now, and where you think we need to go into the future, not only in terms of meeting the needs of parties, but perhaps also in how we manage the pipeline of adjudicators, how we ensure that we've got the right range of skill sets, and we've got a diverse pool of adjudicators to draw from. So over to you, Matthew.
Thanks for that, Lewis. I think to pick apart your question, or the two questions, I'll deal with them in that way. So your first one was, where is adjudication now? And one of the first polling question today, I think everyone seems to think that there's a collective yes, it's serving a purpose, and I understand there's a general consensus that it is a successful procedure. There's approximately about 40 referrals or requests for an adjudicator every week as an average in the UK. That may increase when the next report comes out. So it's showing that it is working. There's several nominating bodies to pick from. I think the makeup of the panelists, the adjudicators, actually, Kim mentioned it before that it is predominantly lawyers, but lawyers and quantity surveyors make up approximately 77% of people registered as adjudicators, with lawyers slightly ahead in that section. And what's, in my opinion, what's been happening over the past few years is we have been training lots of people to become adjudicators. There's a big take up at CIArb and RICS, and there's lots of construction masters law courses that are undertaken by people with the intention of getting a better understanding of the adjudication procedure because they want to become adjudicators or work as a party rep. But what has happened, in my opinion, is the industry has realised that the industry has to change. So people who want to become adjudicators, who have come up against a closed door or several closed doors, have done something about that. And we've had, nominating bodies start up, and there's, one that's reasonably successful and makes a lot of noise on LinkedIn, and that's UK Adjudicators. And that, in my opinion, was started because people want to get opportunities to become adjudicators, because it's very difficult to get onto a panel. And then obviously we've got the CIC low value dispute model adjudication procedure that was introduced as well. And I think, I can't speak for those people there, but what I've watched on that, I do believe that people are actually, one of the reasons, a couple of reasons for that. Firstly, perhaps we need to get access to justice for lower value claims, but also because we do have a surplus of, qualified adjudicators who have done plenty of party rep work and who have also done lots of pupillage work. And are competent enough to make decisions on low value adjudications. So where are we now? I feel like we've actually got things in place. I feel like we have got people who can act as adjudicators. We have got procedures. We've got a cap fee adjudication scheme that techs are run and UK adjudicators run. The RICS have got their own low value dispute procedure and then a summary procedure as well. And we've got the CIC procedure. So it's not necessarily that we have to bring about, in my opinion, lots of change. The change is already there. What we have to do is act on that change. And that requires a lot of people to buy into that. If we can get the clients and the clients' representatives and the contract drafters to buy in to actually introducing or making sure it's in the contract that the low value model adjudication procedure applies, then I feel like what would happen with that is that could spurn off some smaller industries. So if we've got a procedure there which limits the amount of documentation that's actually going to be used or the parties can submit, it takes away the complexity of adjudication. And I mentioned earlier that we could possibly have, people, in organisations upskilling their quantity surveyors, project managers, contracts managers to actually act as the representative for their organisation in a low value dispute procedure. So people could be trained to represent their own companies rather than going externally to lawyers and to claims consultants to do so. What would, in my opinion, then happen is we would actually get more adjudication referrals coming through, because it opens it up down the line, which would mean that these adjudicators who have trained and want to get onto the panels will actually get some fee earning work as well. So I feel like that's an area where it could develop and go to. Now, as well as that, there are, and I've experienced this, over the past few years, there are lots of hurdles for people to become adjudicators. Several nominating bodies all have their own procedures and rules about how you can get onto a panel. And I think if the industry can agree a common approach on what would be a good way, for everybody to be assessed and be able to get onto panels, I think that would be extremely beneficial and would stop, a lot of to and fro-in and, and stop preventing people from applying to get onto panels. I understand some engineering panels require to have experience in engineering contracts or worked in that industry, and that's fair enough. But I feel like we could possibly go that way with it.
Thanks, Matt. Yeah, I think they're all some very interesting points, particularly around making sure that we've got the right pipeline of new adjudicators and that we're not discouraging people. It's interesting actually that it's a question that's been raised in the chat around inertia around the appointment of new adjudicators by AMBs, and having transparency around the processes for that. And I know that for the Chartered Institute, we are sort of currently reviewing how that's undertaken, and I know that some of you have been involved in some of those discussions. Tom, I wanted to bring you in here as well, just to see what your view is. As I mentioned in your bio, sort of towards the session, someone with some experience as in adjudications and an aspiring adjudicator yourself.
Yeah, I think it's very much echoing what Matthew's just said. There are plenty of MSc courses out there. I did the one at King's with Nicholas, and it was very much, there's a lot of enthusiasm going through that. There's a lot of great teaching and talking. There's a lot of opportunities that sort of spring from that, but then you kind of come out the other side of that, and it's very much you hit almost like a brick wall. There doesn't seem to be that gap between taking sort of wannabe adjudicators, if you like, from doing their training through to actually getting experience and then getting them into panels. I think part of that has to be measured with the fact that you can't just you can't just come out of a degree and go, right, off you go, you're going to be an adjudicator, because I don't think that would satisfy the parties. I think there's got to be that sort of training process in there, and I think that's a great opportunity for the CIArb. I know they're very keen and well thought of on the training initiatives, and I think that's something that the CIArb could do. Is there needs to be that need to maintain the quality of adjudicators, and that is going to involve around training them up, making sure that they are adequate enough to actually go out there and make those decisions. And I certainly do feel that's something that the CIArb could capitalise on. And part of that for me as well could be they have the young members group at the CIArb, and I know they do some fantastic work, but they can also use that group as a way of bridging between the two. So you get the people into the young members groups, or even sort of early adjudicator groups, and sort of use that as a training portal for them, give them mentors. And I know there are obviously complications around doing that, and there are various probably challenges and hurdles that need to be overcome in terms of putting that in place. But I think that would be a massive benefit to then getting people onto, as Matthew said, these sort of low value adjudication decisions, where there's the opportunity to learn and obviously also mentor with others, and then grow into the large disputes. And that will also allow the multidiscipline still to come through as well, because I think that's such a key part of adjudication, is that multidiscipline. I know Matthew was saying it's mainly lawyers and QSs, but depending on the types of disputes that come in, there needs to be a good variety of adjudicators with different backgrounds for those questions that arise, because there are technical questions that potentially could come up. There needs to be someone to deal with those. And I think that would be the biggest route to helping people to becoming adjudicators. And that's, for me, my experience is it's that sort of next step of how you bridge the gap between coming off the courses to actually getting onto the panels and obtaining the work.
Thanks, Tom. I think the point about making sure you've got a range of skill sets kind of echoes Matt's earlier point about horses for courses, and making sure that we've got different mechanisms and different adjudicators with different backgrounds to deal with the particular dispute at hand, and not assuming a sort of a one size fits all. I think that point around training as well is really, really key. Obviously, as you mentioned, that CIArb is a very well established training program right across the board. I think we're very well regarded in that respect, and it'd be interesting to see whether there is more appetite for perhaps specialised adjudication courses in that sense, and that's something that'd be really interesting to look at. I wanted to move on now, because I'm conscious that we've got a lot of audience questions coming through. But just before I do, Kim, I think you wanted to. I believe you just raised your hand and you wanted to make a comment. So I'll just hand over to you, and then I'll move on to some audience questions.
Thank you, Lewis. I just wondered, I'd like to come back on a couple of points that have arisen in the discussion. First of all, Nick Gould emphasised that an adjudicator's job is to decide the dispute according to the law. So when your adjudicator bangs on about the burden of proof and the issues and the evidence, they're doing that because they want to produce a result that is acceptable to the parties, especially the losing party. And I often wonder, well, if we're not going to do it by the law, how on earth are we going to do it? Would you like me to get the tarot cards out, for example? And the proof of this pudding is in the fact that most decisions are accepted by the parties. Some do go on to be revisited in court or arbitration, but the vast majority do not. And if you have misgivings about the way the adjudicator nominating bodies work in appointing your adjudicator, you can of course always choose your own. And I know that seasoned bodies, industry bodies who use adjudication regularly, always try to make a choice rather than go to before falling back on an A and B. I'd urge everyone to get some adjudicator qualifications because the training is never wasted. It's always going to inform your dispute resolution practice. And let's bear in mind, we don't pay into our pensions aged 28, expecting them to pay up when we're aged 29. It is a career shaping process. And I had the misfortune to end up in I, A and E recently, and I saw an I, A and E doctor who was about the age of my son. And now I found that genuinely alarming, and I suspect that many industry bodies would have misgivings about their multi-million-pound disputes being decided by someone with youth on their side. And my final suggestion about the future of adjudication is that there's obvious scope here for a tiered process, for having younger, new, vibrant adjudicators deciding smaller, low value, more straightforward, hopefully, disputes, and then a panel of adjudicators who are more seasoned, more experienced, more resilient to the tactics that the parties will use to decide the higher value disputes.
Many thanks, Kim. I think that's very interesting, and I think it kind of again echoes some of the points that's been made around not fragmentation, but about specialization and having that sort of tiered approach, both for practitioners, but ultimately to make sure that the different mechanisms are offered to parties in different circumstances and different levels of dispute. I've got a couple of questions from the audience, and there are actually two that I'm going to ask simultaneously to see your views. They are distinct, but they're both about how current issues are affecting adjudication. So one is about how adjudications have changed in the last 18 months, particularly in the light of Brexit and coronavirus. Have there been more or fewer disputes, and how do the panel feel that that will play out over the next 12 months? And as a sort of a linked question to that, it's how is the climate change agenda affecting construction generally and construction disputes in particular? So does anyone want to come in on those questions? Matt? Yeah,
okay. So, I mean, I can only speak from my personal experience, but when Boris came to the lectern the first time and told us that we were going into lockdown, I quickly drove to the office, grabbed all my files, and I said yes to any inquiry I had, because I thought, that's it, I'm never going to be working, I need to prepare for the worst. We had Brexit on the horizon. Well, the opposite was true. It's been the busiest year in 25 years for me, 2020, in terms of disputes. And then this year I thought, okay, I'm going to actually have some downtime. It's been even, well, at least as busy. And so, and we, in terms of the coronavirus issues, then yes, they are being played out now. You know, we've got a lot of cladding and fire safety issues because ongoing with the sort of the Grenfell sort of inquiry and the sort of changes in legislation, but we're also having the battles now, the goodwill perhaps that might have been there at the beginning. Now somebody's going to have to pay for it, or not, as the case may be. So the responsibility for the delays, disruption, and the, you know, where the risk lies in terms of the impacts of coronavirus are reaching my desk, and I'm sure other people's desks. So in terms of the boom bust, I see it as booming in dispute resolution. In terms of the climate change, I suppose there's a couple of things I've noticed. There's the Green Arbitration Pledge, I think, that Lucy Greenwood has been championing. I've now seen that there's a litigation pledge. So there's an increased awareness. I think I was forced into it in adjudication, mainly because there was no one in the office to pick up all the boxes of paper that were being delivered. So I immediately removed the need for hard copies. Meetings and traveling to meetings means that I guess my carbon footprint is lower because I'll be using platforms such as this. And I think looking forward, I don't want to tempt fate, but yeah, when we eventually get there, although I think I said to some people, I'm now invested in masks. I think it's a good time to buy yesterday. But tomorrow they might be more expensive. But on a serious note, moving forward, these things that we can do procedurally to reduce carbon footprint, in terms of not having lorries delivering boxes, not having all the paper, learning to work online. I've now, I suppose, had an increased awareness. So someone told me that actually sending emails has a carbon footprint as well, but I mean that's perhaps a step too far. I guess as long as we're not having our sort of have to laugh when I look at the this particular space boys party that people are having in terms of who's got the biggest rocket, and there's me worrying about the number of emails I might be sending, and but there you go, that's another story. But on a serious note, I think that actually going forward, we can actually change the way we work, and have, along the lines of the Green Arbitration and the Green Litigation Pledge, a different change of working. It requires people to buy into it, because online exchange of submissions aren't necessarily free. Well, from my experience, they're not free of issues, in terms of being able to access documents, but we are getting better at it. And though, in terms of ordering files and things electronically, it's I think it's a case of moving to the times. And to be fair to the construction industry, I think they've been exchanging documents electronically for some time. I can remember an arbitration about 3 years ago where they said, "Oh, we haven't got a date stamp," and in the print room, and it was the chief executive of a contractor. He said, "Well, we have very little post now. In fact, the old days of the post room and someone going round and stamp received, initial, going down to the next chain of command doesn't really happen, because people are communicating documents, drawings electronically, and as long as you've got the software and the means to print if necessary, then then it's all fine." So I think we've been perhaps forced to move with the times, and actually maybe perhaps one of the advantages of people who've grown up with computers is that it's second nature to them.
Thanks, Matt. Were there any other comments on those questions anyone wanted to make? Go ahead, Kim.
I listened to Lucy Greenwood's debate about the Green Arbitration Pledge, and it resulted in the devastating revelation that the best way, the most greenest approach, the carbon-free solution to all of this is not to have a dispute in the first place. It also actually gets rid of the lawyers if you're, that way inclined. So, and you don't have to worry about where your adjudicator comes from. So, back to the parties really on that one.
Thanks, Kim. Nicholas, were you about to add anything there?
I was just going to say that most adjudications are usually done documents only, so there's rarely a meeting or a hearing. But one thing we've all discovered in the past 18 months is that it's really easy to have a Zoom call or a Teams call with people scattered around the country to have a proper discussion or a debate. So you're not talking about hearing necessarily, I mean sort of a 3-4 hour meeting to discuss points. And and I think I sort of encourage it. I think that's been a really good thing, not just in adjudication, but a way of working with clients and so on and so forth. But certainly also for adjudication, rather than getting everybody travelling to one place to have a discussion, it's possible to have virtual meetings. If you tried to do that 2 years ago, no one would have taken you seriously. But because we've had to do it, we found it actually works really well. And I've had some international adjudications where people are around the world in different countries, and that certainly reduced the carbon footprint of what would have been lots of people flying to one location. So I think that that's a pretty good thing. But I'm also with Matt on terms of struggling a bit sometimes with the technology. People have got different platforms and different firewalls, and each time you crack it, something else comes along. Actually, today we've got a client that wants to give us some documents. They started yesterday, and we still haven't got access to them for reasons that my IT department doesn't understand, and neither does theirs. So once we can look at them, we'll look at them. But I think this is just going to be an ongoing thing, and the part of that is security, isn't it? Because there's more cyber issues that we, in terms of people getting access to stuff they shouldn't. So, there are different challenges there, but I think it's to be welcomed, this sort of way forward.
Thanks, Nicholas. I think we've had some fantastic questions from the audience here, and unfortunately, we're not going to get time to cover all of them, because I know that we're approaching the end of our time. But there is a question here which I think is perhaps a reasonable point on which to close, and I'll ask all of our panelists this. You'll be able to see it in the chat, but does anyone have a personal wish list for changes that you would really like to see made to the adjudication regime in the UK? Now, I know some of this has come up in the discussion, but if each of the panelists we'll go around kind of in order from you, Kim, but if you could say firstly, is there, and if there's one thing or perhaps 2 or 3 things, what would they be?
Well, I don't think we should interfere with the legislation at all. Look what happened last time. We just about worked out what the payment provisions meant, and then they came along and changed them. That is not the way to change. I think the reins of power, the engine for change lies with the adjudicator nominating bodies, and TEXAR have really blazed a bit of a trail on that front, and I'm sure the Chartered Institute will follow. And the thing I'd really like to see is more women adjudicators, please. I mean, at the moment, I seem to be the brooch on my screen layout. I'm the brooch between 2 beards, and Matt and his beardy men at the end of the corridor. I mean, I really do think we need more women adjudicators, please.
Thanks, Kim. I think we certainly the balance, the gender balance in adjudication at the moment is very, very far from where we want it to be. Let's put it that way. So I totally agree with that. Nicholas, was there what are your wish lists?
I hesitate to say this now after Kim has said don't tinker with the Act. I would remove the exception for process plant and the energy industry, that little slither, because it does give people lots of issues about whether it's in or out, and whether there's a hybrid contract with a bit in and out. And I don't think there's any reason to have an exclusion. I just think that the whole of the construction industry be involved in it is a bit different with PFI and development agreements, those things that were excluded in the exclusion order. But that little slither in Section 105, the excluded stuff, nuclear and so on, I would just take that. So adjudicators know if they've got a construction contract for a construction operation, they've got jurisdiction.
Thanks, Nicholas. And Matt Malloy?
Yeah. Hi. Yeah. My hobby horse is bridging the gap between the academic training and practicing. And I think we're at a stage now, and I think the nominating bodies again will take the lead on this, for actually providing some kind of pupillage requirement, perhaps, where the more experienced adjudicators can share their knowledge and give access to aspiring adjudicators to see what it's like on this side of the screen. And I've had, I've been doing it now for probably about 2.5 years, and I've had zero objections from the parties. Appropriate procedures in place for confidentiality. Sharing documents electronically means the burden on the pupil master is relatively slim, and it's actually good for peer review, because now I'll have a debrief with my pupil post decision, and it's very so it's good for the personal development of the experienced adjudicator, because it's a lonely process, but it's also giving people experience so that when they do move on, they can do it with the stabilizers off without falling off the first time.
Excellent, thanks, Matt. And Matthew?
Thanks, Lewis. There's just a couple really for me. One, I'd like to see a greater buy-in or take-up of the CIC LVD model adjudication procedure. I'd like to see that more widely used and in contracts, so the parties can refer disputes under that. And then secondly, he's just making reference to a question that was in the chat from Seth Handley. I would like it would be great if the nominating bodies, the primary ones who get the most requests for adjudicators, look to change any specific rules they have internally that would allow people who are registered on their low value dispute panels to be appointed to deal with any low value disputes. I saw a statistic the other day which was 28% of referred adjudications are less than 50k in value, and 47% were less than 100k in value. So if we've already got a low value dispute panel at some of the main bodies, why not look to use those adjudicators on that, which would possibly mean they have to change their bylaws or their internal criteria, so to speak, to do that. That's what I'd like to see.
Excellent, thanks, Matt. And final word from Tom.
Thanks, Lewis. I think, to be honest, the main thing for me would be probably echoing what Matt Malloy was saying, in that that would be fantastic to see that gap between training and actual practice being bridged. Bearing in mind, it is a process for the parties, and it should be about what the parties want. But definitely, I think A and Bs need to take the lead on that, and helping those with lesser experience, no matter what age, sex, or whatever you are, helping those people to then develop and grow into the adjudicators of the future.
Excellent. I think that's a really good note on which to finish, Tom. I think that's really, really important. And thanks everyone for taking part. I think we've had a fantastic discussion there. I also want to thank our audience for joining us from around the world. Please do join us for future sessions. You will be contacted after this session with a short feedback form. We'd really appreciate any comments that you have on that. It has been recorded, so if you want to re-watch it in whole or in part, it'll be published in the next few days. And we also do have another session in this series coming up, at this Adjudication Insight series, on the 25th of August, the same time, UK time, 9:30 till 11. And that will be really touching, sort of following on from many of the points that people have raised today. Low value adjudication, how can A and Bs better cater to smaller disputes? You can sign up for that already on CIArb.org/events. Please do join us to take part. And with that, thank you again to everyone for joining us from around the world. It's been a pleasure to join this. I've really enjoyed the discussion, and I will hope to see you all again soon. Thank you.